John, if you don't mind, we'd like to test that one more time.
Okay, testing. Can you hear me, Michael?
Okay,
Testing.
standing by. Okay, we're up and running. Many thanks.
Okay.
Sorry about the interruption.
Okay, thank you. Is everyone back? Thank you for your patience and appreciate your help there, Michael. As we were going through our roll call, the last person I didn't get to was Michelle, our court reporter. Are you hearing us okay? Oh, I think you're
Yes,
muted.
I'm sorry. I had to unmute.
Okay, so you're all right. It's most important that you hear all of us.
Yes.
So, okay, good.
Thank you.
Well, as we were thinking, this is the first time the division has attempted a electronic meeting like this with everyone being in different places. And so I appreciate the ability of our technical staff to get this together. I'd like to thank Paul Gedge, Michael Van Hatten, Michael Christensen, and Carmen McDonald. We were only in this a few minutes and we already needed them. So thank you very much. And also thank everyone else that is willing to participate remotely so we can continue with our work as best we can in the face of this self-isolation and COVID-19 pandemic. So I'd like to continue on. This matter being presented today, again, was docket number 2020-007, cause number 60201. It's a request for agency action for XCL Resources, LLC, for an order pulling all the interest, including the compulsory pulling of the interest of certain non-consenting and unlocatable owners within a 1280 acre or substantial equivalent drilling units established for the production of oil and gas and associated hydrocarbons for the Lower Green River-Wasatch Colton formations, comprised of first, sections 14 and 23, Township 2 South, Range 1 West, Uintah County, Utah, and the second drilling unit, section 30 and 31 of Township 2 South, Range 1 West, Uintah Special Meridian, Duchesne County, Utah. At this time, we'd like to take appearance of the counsel for the petitioner.
Yeah, Mitch Mayo of Lear & Lear PLLC on behalf of XCL Resources.
Thank you. And for the division?
Gordon Rowe, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Okay. And acting as my counsel is Haley Sosa of the AG's office. At this time, I'd like to turn the time over to Mr. Mayo for the presentation of his case. But before we get started, I think it'd be best to swear in our witnesses at this time. Mitch, do you have, I believe, two?
That's correct, Mr. Rogers. John, thank you for appearing and agreeing to do this today. And I'd like to also thank the division and their IT staff for accommodating this hearing. The witnesses I have today are Kevin Annenson, Vice President of Business Development and Land, and Josh Sigler, who is the Vice President of Geology. Michelle,
Okay.
can you swear in the witnesses, please?
Before we get started, does the division have any witnesses they need to be sworn in?
Just Mr. Dane Doucette at this time.
Okay. All right. I'm not sure how we do this, Michelle, over the computer, but let's give it a shot, okay? Can we swear them in?
Yes. Will you all raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
I do.
Okay, great. Thank you.
Okay, I heard those all were affirmative, so I appreciate that. I think now we will turn the time over to Mr. Mayo for the presentation of his case.
Okay, thank you all. A couple quick kind of housekeeping notes. We mentioned it earlier. Everyone's at home in their own places. If there are interruptions, obviously, please let me know. I'll be doing, unfortunately for everyone here, most of the talking today, I would imagine. So please feel free to interrupt me if need be, so we're all on the same page. Also, I typically turn my cell phone off during any sort of hearing, but I've left it on during this hearing so that I can communicate with my clients if need be, since we can't just lean over across the table and discuss things. If that comes to be an inconvenience, please let me know that. And if I check my phone, please forgive me. I'm trying to communicate with my clients.
And Mitch, Mitch, before you get started,
Sure.
just a point of clarification, we'll be in the same situation. If I have to counsel with Haley, we'll mute it and then talk on our cell phone. So we'll have to, it'll be a little more burdensome than it usually is, but that's just the way it'll be, okay?
Perfect. Okay, sounds good to me. I will try and keep this hearing as brief as possible, but obviously there's a lot of information to get out. So we'll just begin with that. The resumes of the witnesses, Mr. Ananson and Mr. Sigler, have been submitted as petitioner's Exhibit A. We also submitted a resume of Mr. Mark Grave. That was done out of an abundance of caution to make sure we had the appropriate witnesses who were able to appear today. He will not be appearing as a witness today. If asked about their resumes, Mr. Ananson and Sigler would confirm that those are accurate and true. Although XCL is relatively new to the basin, both of the witnesses here today actually appeared before this hearing examiner, Mr. Rogers, in February in cause number 475-01. In that cause, similar to this cause today, Mr. Ananson offered fact testimony and Mr. Sigler offered expert testimony in geology and general development operations. With presumed stipulation from counsel, Mr. Sigler will be testifying as an expert again today. If division would prefer, I'm happy to qualify Mr. Sigler.
Okay. Gordon,
No,
would you like him to review his resume and experience?
no objection from the division. We're familiar with the witness, and he's fine to be sworn as an expert.
Okay, we'll accept him as an expert witness in this matter. Thank
you. Standard practice, I'm going to move for admission of all of our exhibits at the end of the case in chief. As Mr. Rogers pointed out, this cause today involves two 1280 drilling units, one in sections 14 and 23, 2 south, 1 west, and one in sections 30 and 31, 2 south, 1 west. I'll probably refer to those for simplicity as the 14 and 23 DU and the 30 and 31 DU. Both of these produce from the Lower Green River and Wasatch Formation. The 14 and 23 DU was established by the board in May of 2018 in cause number 139-149. And the 3031 DU was established by the board in July of 2016 in cause number 139-138. We've submitted both of those orders as exhibits, but we won't be discussing those here at the hearing today. Relevant to this hearing, XCL has drilled, and their predecessor in interest, Axia, has drilled the following 6 wells on these units. In the 14 and 23 DU, the Butcher Butte number 23-74H-21 well. And in the 30 and 31 DU, there are 5 wells at issue today. The Butcher Butte 30-21H-21, the Butcher Butte 30-61H-21, the Butcher Butte 31-114H-21, the Butcher Butte 31-144H-21, and finally the Butcher Butte 31-64H-21 well. These 6 wells I'll probably refer to collectively just as the wells or the subject wells. Although there were 4 unleased mineral owners identified in the request for agency action in this cause, one of those owners, HC Ridgeside Energy Partners, LLC, has sent a copy of that lease to XCL, and their lessee has signed and returned the JOA. So HC Ridgeside has been removed from this. At this point, there are 3 unleased mineral owners subject to this forced pooling request. There is one in the 14 and 23 DU, and that owner owns 0.125 net mineral acres, or roughly 0.09% of the drilling unit. In the 30 and 31 DU, there are 2 unleased mineral owners, and they collectively own 0.74 net mineral acres. Together, the unleased mineral interests at issue today own less than 1 net mineral acre out of the 2,560 at issue. In addition to the unleased mineral owners, there are several working interest owners who are either unlocatable or have otherwise not yet made an election to participate and share their proportionate share of the costs. There are 6 of these owners in the 14 and 23 DU, and they own a collective 8.7% of the drilling unit. And there are 9 owners in the 30 and 31 DU who own a collective roughly 0.4% of that drilling unit. Oh, my apologies. In addition to the mineral and working interest owners identified, XCL also seeks to pool, to the extent necessary, the estates that we identified in Exhibits 3 and 4 to the request for agency action. XCL believes that they have contacted and leased and secured participation from all of the owners who take under those estates. However, because probate proceedings have not been completed or XCL has not been furnished with the probate orders resulting therefrom, out of an abundance of caution, we have to force pool the estates to ensure that all of the potential heirs or devisees of those estates are appropriately pooled in these wells for production. Notice has been provided to all of the unleased mineral owners, the unlocatable mineral owners, and these estates through publication in addition to regular mailing. Affidavits identifying these publications are included as Petitioner's Exhibit AS in this cause. Because no interested parties have timely objected to this request for agency action, pursuant to the Utah Admin Rules, R641-104-150 and R641-108-400, XCL would move to enter default against those parties. In this hearing, we will also seek to apply the terms of the JOA, the acreage weighted average landowner royalty, as shown in Exhibits S and T, respectively. It's worth noting that the terms of the JOA have been found to be just and reasonable by the board in prior hearings. As I said before, notice was provided to all interested parties, as that term is defined, via mailing of a copy of the request for agency action to their last known addresses of record and through publication. Petitioner's Exhibit AT contains photocopies of the certified mailing receipts mailed in this matter and the return results from that as well. Finally, the board has jurisdiction over this cause pursuant to Utah Code Section 40-6-6.5. And it is our belief that the testimony and evidence presented here today will establish that the regulatory and statutory requirements to deem the unleased and uncommitted working interest owners, the unleased mineral owners and uncommitted working interest owners as non-consenting parties, as that term is defined, and to compulsory pool their respective interests into the subject wells and their associated drilling units has been met. With that, I will begin my examination of Mr. Annenson if there are no questions. Mr. Annenson, please begin by stating your name and business address for the record.
You there, Mitch? Can you hear me?
I can, yep.
Perfect. Okay. Kevin Annenson. I'm the VP of Land at XCL Resources. And our address is, since we're still kind of in the new office, is 3217 Montrose Boulevard, Suite 200, Houston, Texas, 77006.
Okay. And please provide the corporate and bonding status for XCL if you could.
Say that one more time, Mitch. I'm sorry. I missed that.
Oh, sorry. Could you please provide the corporate and bonding status?
Sure. Yep. Okay. XCL is a Texas Corp, and we are in good standing. We have a principal place of business, like I just mentioned, here in Houston, Texas.
Okay. And you are fully and appropriately bonded with all relevant state, federal, tribal agencies. Is that correct?
That is correct.
Okay. First, I'd like to move on to a couple of exhibits that kind of help orient everyone to the lands and wells we're discussing here today. I hope that everyone here, I'm going to begin presenting, I believe. Let me see if I can do this effectively. Can John, Kevin, can you see my screen? I'm assuming everyone can if you can.
I can.
Yeah. Yes, I can see it.
Okay, I'm gonna try and keep it at a view that's visible to everyone. If you have difficulty seeing it or it just doesn't show up, please interrupt and let me know. And please have patience as I go back and forth between the two. The first exhibits that I'd like to direct you to, Mr. Ananson, are exhibits D, which begins at page 2. And exhibits E through J. And there are a lot of pages here. You have, I'm assuming you've reviewed these exhibits in detail, Mr. Ananson. Do you recognize these exhibits D and E through J?
I do.
Okay. And were these prepared by you or under your direction or supervision?
Yes.
Okay. Let me go back to Exhibit D. Can you just help full screen? Can you help orient the board as to where we are and where the wells, the drilling units at issue are today?
Yep, sure thing. So this is just kind of, as you mentioned, the general geographic location of the 2 wells we'll be discussing today. As you can see, one of the wells there falls right east of Roosevelt, and then the other unit we'll be discussing falls right there southwest of Roosevelt, and we're in a 2 south, 1 east, 14 and 23 right there. Then same thing, but with 30 and 31.
Okay, and I believe you meant 2 south, 1 west. Is that correct?
I'm sorry. Yes, 2 south, 1 west. Yes, sorry.
Okay, thank you. Exhibits, just for everyone's notice, and maybe to, if I may, I'm going to stop presenting for a second. Gordon, Haley, and John as well. If there are concerns, there are obviously multiple drilling units at issue, and we have what are essentially duplicative exhibits for each of the 2 drilling units. I would like to obviously go through both of those, but if there's interest, I can try and go through in detail one of the sets and kind of summarily with the other set for the drilling unit. If you have an issue with that or would like me to do it a different way, please let me know, but that's my plan on proceeding.
Mitch,
Yeah.
I had a little bit of disruption here internally. Could you
Oh,
say
shoot.
that?
No, you're fine. I just wanted to make sure it was okay. There's obviously 2 drilling units here, and the information.
I'm sorry.
No, that's okay. She's well. The information that we submit, we've got essentially duplicative exhibits showing for the 14 and 23 DU and the 30 and 31 DU. What I had planned on doing today is kind of going through in detail one set of each exhibit and then summarily going through the exhibit. So for example, going through the exhibits in detail for 14 and 23, and then asking the kind of conclusory questions that apply to sections 30 and 31. I figured that would save time and everyone's sanity. But if you'd prefer differently, I'm happy to present in detail on both.
No, I think that'll be fine.
Okay. I will go back to sharing my presentation. Okay, then I'm going to have you look next, Mr. Annenson, at Exhibit E, which is here, and Exhibits E1 and E2, which are here. Exhibit E, if you wouldn't mind just telling the board, oh, thank you, what this is and what it shows.
Sure, and I'll follow your scrolling, Mitch, as you go through. So what this is the one of the units here for the hearing. It's a 2 South 1 West, obviously zoomed in on sections 14 and 23.
Okay, and that's probably something you refer to as a well plat.
That's correct. That's correct.
And then this tract plat map, please explain what this is and what it shows for sections 14 and 23.
Zooming in on mine real quick.
I wonder if I can zoom in. Does that help?
Yep. So what this is this is all of the so you can see all the tracks within 14 and 23, and as you can tell, there's 55 of them. So there's quite a bit of tracks here that we're looking at.
Okay. So these just show essentially the well plat, the direction and location of the well in the 14 and 23 DU, and also the fractionation of ownership in the 14 and 23 DU. Is that correct?
That is correct.
Okay. You've also submitted exhibits E1 and E2. I'm not going to go into detail on those, but those are tract ownership schedules. What do those demonstrate? Obviously, aside from the namesake, tract ownership. Relevant to this hearing, what do those demonstrate?
What that is showing is each one of the mineral ownership through each tract and what their interests are.
Okay. And the reason that's submitted is so that we can identify the unlocatable and or non-consenting parties in the relevant drilling unit, correct?
That is correct.
Okay. Could you please talk a little more in detail about these unlocatable and or non-consenting parties in the 14 and 23 DU?
Yep, sure thing. So what we did is we sent out, whether they were mineral interest owners, if they're mineral interest owners, we sent out elections to participate, certified mail. And if they were working interest owners, we did the same thing, but without the option to lease. But in the mineral interest owners, we gave them the option to lease or to participate in the wells. For the working interest owners, we gave them the option to participate in the drilling of the well. Also sent JOAs along with that. Subsequently, if it came back unlocatable, we also looked up various other addresses through other sources, and we also went back and did additional research within the county records to make sure there was no other action or no other last known addresses that may have popped up.
Okay. And you XCL recently acquired this interest from Axia. Is it safe to assume, and can you testify as to whether Axia undertook similar interests when they owned this asset?
That's correct.
Okay. And so could you please, Mr. Annenson, describe for us who the unlocatable and or non-consenting owners are, both working interest and mineral owner in the 14 and 23 DU?
Sure thing. We have Mega Petroleum, and I'm sorry if I mispronounce any of these. I believe it's Delphia Consulting Inc. Kyle Weir, or Weir Kyle, as it's written there. Lawrence Zicklum, and Bernice Cohen.
Okay. And those are the unleased, those are the unlocatable and or non-consenting working interest parties in tracks 1 through 7 and tracks 23 through 32. Is that correct?
That's correct.
And we have, in addition, and I will, one moment. In addition, there is one other party, Altamont Energy LLC, who is, as of today, non-consenting, and they are in tracks, they own an interest in tracks 33 and 38. Is that correct?
That is correct.
Okay. As far as mineral owners, are there any unleased mineral owners identified in the 14 and 23 DU? Let me see if I can.
Yeah, sorry, Mike. Trying to pull up both here at the same time.
I've got to do a better job driving. I apologize. Let's see.
So got it right here. Yes, we have Shiners Hospital for children, and then as you stated in the beginning, we had previously HC Richside Energy Partners, but they have since then actually leased their interest.
Okay, so Shriners Hospital for Children is the sole unleased mineral interest in the 14 and 23 DU.
That's correct.
Okay, and they own about 0.1 net mineral acre in the DU, correct?
That's correct.
Okay, and how are these ownership interests determined? How do you determine these? You know, do you?
Sure. Yeah. So what we do is we have somebody go through the courthouse to run a from Patton to pull all the interest, doing an abstract, and then from there we send it over to a title attorney for further examination. The title attorney puts together the title opinion. Once either XCL or our predecessor actually received it, we go through it pretty extensively, and once we notice any type of unleased mineral interest, anything like that, we go back and do additional research just to make sure that is the case, or from when we receive the title opinion going forward, that those have indeed not been leased or sold or anything to that extent.
Okay. And it's true that Lear and Lear prepared division order opinions for Axia before you took over this asset related to the 14 and 23 DU. Is that correct?
That is correct.
Okay. And do you know when those were completed?
Yes, I have it right here. It was completed on January 9th of 2020.
Okay. And that's the DU or the division order for section 23.
That's correct. And
do you know the same date for 14 as well?
14 was February 7th of 2020.
Okay, so fairly recent for both of those.
That's correct. Yep.
Okay. And so if I may sum the testimony for confirmation, just to make sure we are all on the same page, Mega Petroleum, Delphi Consulting, Weir Kyle, Lawrence Zicklin, and Bernice Cohen, together with Altamont Energy, collectively own about 8.7% of uncommitted working interest in the unit to date. Is that correct?
That's correct.
And XCL has tried to contact them at their last known addresses of record, which have either been returned undeliverable or the parties simply have yet to make an election as to whether to participate.
That's correct.
Okay. There are nearly identical exhibits for the 30 and 31 DU. I'm going to just pull those up briefly so everyone can see them. 101. We have the 30 and 31 tract plat. And then similarly, we have the 30 and 31 tract ownership schedules in exhibits F1 and F2. Is that correct?
That's correct.
Okay. Please, if you would, Mr. Ananson, briefly talk to us about the unleased and uncommitted owners who are identified in these exhibits.
I'm trying to get here on the same page, Mitch. I'm sorry.
No, you're fine. 8's probably where you're headed.
Okay. Okay, so what we have here is on tracks 3 and 4, the working interest owners who are unlocatable and or non-consenting is North Plains, Held by Production Inc., Saltzman Freed Nash and Company, MMS Energy Investments Group, Nicor Drilling Company, Western Investments, Overthrust Resources, and that's Resources Ltd. Discovery Series 5, Overthrust Resources Discovery Series 3, and Rosewood Limited Partnership. And we had an address for all these working interest owners, mailed them well proposal packets in the beginning of November 2019, which was returned undeliverable for all but Held by Production Inc. And MMS Investments Group 2, who received the well proposal packets, but I think Mitch, like you had said, but had yet elected to participate.
Okay, so just to sum that up, there are 9 working interest parties in tracks 3 and 4 who are unlocatable and or non-consenting. Axia sent out well proposal packets in November of 2019 on XCL's behalf. Those were returned undeliverable for 7 of the 9. Held by Production Inc. and MMS Energy Investment Group 2 Inc. received their packets but have not yet made an election. Is that correct?
That is correct.
Okay. And let's go to, if we could, tracks 6 and 13 for the unlocatable and or non-consenting parties, the unleased mineral interest owners. Could you please discuss those for the board or the hearing examiner, excuse me?
1 second here. Okay, so for track 6 and 13, unleased, we have Wells Fargo Bank. Sorry. Formerly known as the First Security Bank of Utah. Trustees of Ida Mahan Phillips Revocable Trust. I think you guys can see it there on Mitch's screen. And then
And as
also
trustee of the Evans Jonah Phillips Revocable Trust Agreement, successor in interest to Evans J. Phillips and Ida M. Phillips as joint tenants.
you're much better at it than me, yes.
Well, I've got the screen in front of me here. That's a little easier to read. I'm not sure how it's showing up on your end, so I apologize.
It's okay. It's a little small. I keep trying to look at. Can you go ahead and name the other one and I'll just confirm?
Sure. The other owner in tract 13, let me see if I can just skip down to that, is Wells Fargo Bank Northwest NA as successor to First Security Bank of Utah. Is that correct?
That is correct.
Okay. And so in sum, there are 2 unleased mineral interests in the 30 and 31 DU. Is that correct?
That is correct.
And those 2 own collectively about 0.75 or about 3/4 of a net mineral acre in that unit?
That is correct, Mitch.
Okay. And these, it's safe to assume these ownership schedules were prepared in the same way by preparation of a drilling order title opinion by Lear and Lear?
That is correct.
Do you know the effective dates of those title opinions and any update that was done to get title as clear as possible heading into this process?
Yeah, sure thing. Section 30 was originally back in August of 2012. However, there was an updated ownership report that was done in September of 2019. And then for Section 31, We had an original one done in 2017, but subsequently have a updated ownership report dated September of 2019. So they've been within the last couple months.
Okay. And both Axia and XCL have undertaken significant efforts to contact, locate, and secure the leasing or participation of all the interest owners identified in the 14 and 23 and 30 and 31 DU. Is that correct?
That is correct.
Okay. Next, I would like to move to several exhibits that collectively, that are best discussed collectively. So let me do that, and please forgive me for a moment. Exhibits K through R. K and L are JOAs that are applicable to section 14 and 23 and 30 and 31. And exhibits M through R are titled authority or authorization for expenditures that are applicable to the 14 and 23 well, and then subsequently to the 5 wells that have been drilled in the 30 and 31 DU. Do you recognize these exhibits, and are they official business records of XCL?
I do.
Okay, and they are?
Yes.
Okay. These, in addition to these exhibits, I'd also like you to look at, I will show you one of these. There are several, about 140 pages of these, but exhibits U through exhibit AR. These are titled Well Proposal, and it's a letter. Can you tell the board what these exhibits are? Excuse me. Let me ask a different question if I can.
Yeah.
Exhibits U through AR are several copies of letters with return receipts. They are titled Well Proposal. Are those, in fact, well proposal letters sent to the interest owners in these units?
They are.
Okay. And so collectively, exhibits K through R, the JOAs, and the authorization for expenditures, together with the well proposal letters contained in exhibits U through AR, collectively those constitute a well proposal packet that you or Axia typically would send to a working interest or mineral owner to secure their participation in any given well. Is that accurate?
That is correct. Yes.
Okay. Give me one moment here. One point of clarification, if I may. Exhibit 240, this is to Mega Petroleum Inc., who is identified as one of the unlocatable and or non-consenting working interest partners in the 14 and 23 DU. This exhibit U is an example of a well proposal letter typically sent to a working interest partner. Is that correct, Mr. Anderson?
That is correct.
Okay. And the pull up a different example. Exhibit 267. Oh, wow. Sorry about that. Page 267, exhibit AD, petitioner's exhibit AD, is a well proposal letter dated January 7th, 2019 that is addressed to HC Ridgeside Energy Partners, LLC. And instead of being titled a well proposal, it's titled a proposal to lease or sell or participate in the well in the 14 and 23 DU. Is this typical in your experience of the type of election letter, proposal letter that would be sent to an unleased mineral interest owner in one of these drilling units?
Yes, it is.
Okay. And do you know what dates approximately these well proposal packets were sent to the owners in the 14 and 23 DU and also in the 30 and 31 DU?
Yes. So on 14 and 23, they were kind of sent on a continual basis between August of 2019 and September of 2019. So within that span.
Okay.
And then for 30 and 31, they were all sent within the month of November 2019.
Okay. And you, XCL didn't acquire this asset officially until around the end of December 2019. Is that correct?
That's correct.
So it's safe to assume that Axia Energy, as identified on this exhibit, is the party who sent out these well proposal letters and maintain the records as your predecessor in interest of these well proposal letters.
That's correct. And once closing and acquiring, working with XCL.
Okay. And these became, after the acquisition, business records of XCL.
That is correct.
Okay. Now I'd like to move to exhibit, petitioner's exhibit AT. That is located at beginning at page 392. Can you identify, do you recognize this exhibit?
I do.
And was this prepared by my office under your direction or supervision?
It was.
Excuse me. Please tell the board what this exhibit is and what it demonstrates.
Sure. So this is just a copy of the returns for the proof of service for the request for agency action for each one of the interested parties.
Okay. So at your direction, we filed the request for agency action and then caused to be mailed a copy of that request to every interested party identified in the certificate of mailing on file in this cause.
That's correct.
Okay. I know that HC Ridgeside, as we've discussed, responded and has leased and now is removed from this. Did any of the other mineral interest owners respond to these letters or otherwise seek to lease their interest to XCL?
Yes.
Okay. And can you tell us briefly about that?
Yeah, on the HC Ridgeside, as we discussed earlier, they had taken a lease and we discussed JOA and got all that information over actually as of yesterday and continue to negotiate with any of the other interested parties or mineral owners.
Okay. And even though, I mean, it's neither here nor there, it's XCL's position that the election period has expired, you still let HC Ridgeside lease their mineral interest and let their working interest partner participate in this well.
That is correct.
Okay. Did you, but you didn't receive any responses from any of the other three mineral interest owners who are unleased in these DUs?
That's correct.
Okay. And you've testified, but I'm going to ask you to confirm one more time whether a copy of this was mailed to the last known addresses for the unlocatable working interest owners where you had those addresses?
That is correct. Not only the last known addresses of record, but we, like I said earlier, we've also done our diligence and research through other avenues on the internet.
Perfect. Did you, in addition to mailing that, did you make any other efforts to notify them of this request for agency action that we're here dealing with today?
Yes.
And how was that notification completed?
Yeah, so we published a notice of opportunity to lease or participate in the oil and gas wells in the Salt Lake Tribune. The
Deseret?
The Deseret News, the Vernal Express, and the Uintah Basin Standard. And I believe that was done on 2 consecutive weeks. Yeah, 2 consecutive weeks.
That's right. And that was pursuant to a board order allowing for the the publication of notice as an alternative because of the existence of unlocatable owners. Is that correct?
That is correct.
Okay. And what is this notice of opportunity to lease or participate that was published? What is it? What is the intention? What does it do for these owners?
Sure. I mean, it's intended to provide notice to all these unlocatable working interest owners and all persons claiming an interest in the subject wells of the request for the agency action, and allow them a way to participate in the subject wells. Okay.
And then I'm going to direct you next to exhibit what's been identified as exhibit AS. Do you recognize this? And was this prepared by my office at your direction or supervision?
Mitch, what page are you on? I'm so sorry, just so I can.
No, you're fine. I'm on page 12.
Okay. Yes.
Okay. And can you tell the hearing examiner what this exhibit is and what it shows?
Sure. So this is a copy of the affidavits of publications, which was prepared by the newspapers, verifying that they each published notice of the offer to lease, participate in the oil and gas wells, and the supplemental request for the agency action within those 2 consecutive weeks that we discussed.
Okay. So just to sum, you provided the unlocatable owners, anyone who you didn't have a direct way to contact, with mailed notice at your best attempt to do so, and also with published notice. Is that correct?
That is correct, Mitch.
Okay. Finally, well, not finally. I've got a couple more exhibits for you, if you don't mind. I'd like to go next to exhibit S and exhibit T. Let me show you briefly what those are for the internet. As with the others, I'm gonna address in detail one of them, and we'll do a summary of the other. Let me pull this up. Can you see that clearly, Mr. Anderson?
I can.
Okay. Do you recognize this exhibit?
Yes.
And was this prepared by my office with your input and review?
Yes.
Could you please tell the board tell the hearing examiner what this exhibit is and what it's designed to do?
Sure. So, this table is used to calculate the average weighted landowner's royalty for both DUs here.
And the average weighted, the acreage weighted average landowner's royalty is what will be assigned to the unleased mineral interest owners who are compulsory pooled, if they are compulsory pooled here today. Is that correct?
That is correct.
Okay. And can you please walk through this? I know the total unit acreage in the 14 and 23 DU that we're looking at here is 1,280 acres. But you have used, it looks like 1171.96 roughly acres for the calculation. It's safe to assume that this is because the statute limits the landowner's royalty calculation to fee mineral owners who are leased prior to the commencement of drilling. Is that correct?
That is correct.
Okay. The same evidence, obviously, or the same discussion applies to the Exhibit T for the 30 and 31 DU. Could you please go through this exhibit and kind of help explain to the hearing examiner and those participating in the meeting how the calculation is done?
Sure thing. So as you can tell from the exhibit here is we take each lease from that particular township range section, and what we actually do is we divide the leased net acres by the total leased fee net acres, which, as you just explained, is the 71.96, excluding the folks that need to be excluded. And what that comes up with is our participation factor. At that point, once we get that participation factor, we then multiply it by what the lease royalty rate is. And that gives us our weighted royalty. After that, we sum up all the weighted royalties. And you should be able to scroll to the last page. As you can tell, this is a pretty large segmented track there. And we get to the end, I just haven't got to, and which is the 17.246, and that gives you what your total weighted royalty is.
Okay. And so the acreage weighted average landowner's royalty for the 14 and 23 DU to be assigned to the one mineral owner who, if they are force pooled here today, is 17.25 essentially percent royalty. Is that correct?
That is correct, Mitch.
And what is the acreage weighted average landowner's royalty applicable to the 30 and 31 DU?
Let me get to that page. I'm having a little trouble seeing it here. It is 16.85.
Okay. And that's a rough approximation. Just so I can get this clearly on the record, I should say this again. For the 14 and 23 DU, it is 17.246334%. And for the 30 and 31 DU, it's 16.848083%. Is that correct?
That is correct, Mitch.
Okay. Finally, and I do believe this is finally, the last exhibits that I'm going to have you address today, Mr. Anson. I'm going to turn you to exhibits K and L. Those exhibits are the JOAs that are on file in this cause, and we will do the same as prior exhibits. We will discuss exhibit K, applicable to the 14 and 23 DU in detail. I'm going to zoom in. I don't know if this is helpful, but do you recognize exhibits K and exhibit L?
I do, yes.
And are these business records of XCL resources?
They are, yes.
Okay. And what model form are you using for the JOAs in the drilling units at issue today?
Sure, this is the AAPL form 610-1989 model form operating agreement.
Okay, and that's usage of that is standard practice in the basin, is it not?
It is, yes.
In your opinion, are the terms of this JOA reasonable and customary in the basin?
Absolutely, yes.
Okay. Are there any modifications from the standard form relevant to this hearing?
Yes.
Let's see. Let me pull up an example. Can you give me an example of one of those?
Sure, I'm trying to zoom in here. So on here, can you zoom in there a little bit? I think you can see it there. Yep. Thank you. So there on the, this is the risk compensation penalty, and here. So on these, we've got the 100, 400 risk assessment penalty.
Okay. And this is a blank form on the JOA that is filled out by each operator in negotiations with their non-op partners. Is that correct?
That is correct.
Okay. So this is the agreed upon percentages for the 100% is applicable to essentially surface equipment, tangibles, and the 400% to intangibles.
That's
and
correct.
These were agreed upon through negotiation with other non-op partners in the 14 and 23 and 30 and 31 DUs. Is that correct?
That is.
Okay. What risk assessment penalty are you seeking, or is XCL seeking to apply today through the request?
Sure. The 100% for our tangibles, and then the 300% for our intangibles.
Okay. Has XCL, or would XCL, enter into JOAs that contain similar terms as those detailed in these exhibits K and L?
Yes.
Okay. I'm going to turn you again to sub portion of the JOA, Exhibit C, the COPUS. Can you briefly explain to the board or the hearing examiner, excuse me, what the purpose of the COPUS is in a JOA?
Sure. This is just the form for accounting procedures, which are applied in conjunction with the operating of the wells here for both of the JOAs.
Okay. So, oh, sorry. Go ahead.
No, you're fine. That was it.
So essentially, this is the way you invoice your partners. These are the terms under which you invoice the other owners in the unit, and under which they're obligated to pay under the unit.
That is correct.
Okay. I'm going to have you look at the third paragraph here. This is going to be difficult to see, so I'm with indulgence from those on the call. I'm going to kind of walk you through this a little more in detail. Paragraph C is titled "Advances and Payments by the Parties," and can you tell the hearing examiner generally what this provision provides?
Sure. I mean, generally, this provides for the assessment of the interest on late payments for the well cost.
Okay, so unpaid well costs are assessed interest, and this provision says that these unpaid balances, quote, shall bear interest compounded monthly at the prime rate published by the Wall Street Journal on the first day of each month the payment is delinquent, plus 3% per annum, or the maximum contract rate permitted by the applicable usury laws governing the joint property, whichever is the lesser. If the Wall Street Journal ceases to be published or discontinues publishing a prime rate, then it's the prime rate published by the Federal Reserve plus 3%. Is that how interest is calculated under these exhibits K and L, the two JOAs at issue?
That is correct.
Okay. And let me quickly dropping things over here. The last provision of the JOA that I want to talk about, and I just want to talk briefly about it, is this section 3 of the COPUS titled Overhead. Can you please tell the board what this clause provides and why it's included?
Yeah, I think kind of like you just said, it deals with all the overhead expenses and applicable fixed rates.
Okay. And in your assessment, are the terms and conditions of the JOAs in exhibits K and L, specifically including those terms discussed in exhibit C to the JOA, are they reasonable and customary in the basin?
Yes.
Okay. And were you asked by any of the interest owners in this unit to modify the terms of the JOA that we have discussed here today?
No.
Okay. With that, I am done with Mr. Ananson. If I may, I'm going to take a brief mute. Actually, I'm just going to pause for a second if everyone will forgive my silence. Okay. I think we're ready. It sounds, I'm guessing my next witness is ready and available. Mr. Sigler, are you there and tuned into this part of the hearing?
I am.
Okay, good. Thanks for your patience.
No problem.
Will you please state your name and business address for the record?
Mitch,
Yes.
just briefly, would you like the division to cross-examine your first witness now, or should we wait till we get through all your witnesses?
That's entirely up to you. Mr. Sigler's testimony is much shorter, but I'm happy either way. Gordon?
Yeah, I'm happy either way. I think whatever John.
I would prefer just to have the division question now, and then we'll move on to the geology part. If that's okay. You all right with that, Gordon?
Yeah, that sounds great to me.
Okay, Mr. Sigler, stand down. Mr. Annenson, are you still there?
I am.
Okay. Gordon, the time is yours, I guess.
Okay. I have a few questions, and with that, unless there's any objection from everyone participating today, I invite Mr. Doucette to chime in, as it's kind of difficult to conference with him with any questions of his own or clarifying points. But first, I think importantly, there's a point of clarification. In your, if I'm reading your request correctly, with respect to your risk compensation penalties, on page 11, it seems to indicate that a non-consenting penalty would be applied up to 400%. However, in Mr. Annenson's testimony, he testified to a maximum of 300%. Would you mind clarifying that, Mr. Mayo or Mr. Annenson?
You're muted, Mitch.
You're muted, Mitch, yeah. Mitch, you're still muted.
Control D is probably the easiest.
Control D. Okay, am I back?
You're back.
Okay, I'll answer that quickly. The statute, as we're all aware, allows for up to 400%. Those of us who've appeared before the board know that's a heavy lift, but that was included just to match the statutory language. What XCL is requesting today is 300%. So I apologize for the confusion.
Okay, great. That clarifies it. I just want to make it clear for the record that XCL is requesting 300%, not the statutory maximum of 400%.
Correct. And I will mute myself again. Gordon, if you would like me to navigate the presentation, just let me know.
Okay.
Okay.
And thanks for that clarification. That was kind of the bulk of my concerns. Just for clarification, how many parties total are you seeking to compulsory pool, both working interests and parties in each of the two units?
Mitch, you're muted again if you're trying to talk. Sorry.
The collective parties, let me see if I can find an easy way to tell you that. I know there are 3 mineral interest owners, 1 in the 1423 and 2 in the 30 and 31. There are at this time 6 working interest owners in the 14 and 23 DU and 9 in the 30 and 31 DU. I can give you names on those if you'd like.
Okay, no, I was just looking for the numbers, especially since it sounds like you had another working interest owner sign on since the request, and all the exhibits you presented today, have those been updated to account for the additional sign on?
They have not. The only I guess modification that would be in there would be a modification to, and I don't even know if it would be an appropriate modification necessarily. The tract ownership schedule in, I want to say it would be E1, and that would move HC Ridgeside from unleased to leased would be the only modification. I can do that if the division hearing examiner would like that. It should be noted, obviously, they were not leased, and so there is no need to remove their lessee from the pleadings. We didn't know that a lessee existed prior to this process, so it would just be moving HC Ridgeside from unleased to leased.
Okay, yeah. Go
I
ahead,
would
John.
prefer that. If you could do that, so we have an accurate representation.
Okay, and we can also, we'll obviously specify exactly in the order that's prepared if this request is granted, who the owners are who are being pooled.
Okay.
Thanks.
And Mitch, I don't mean to be cross-examining you too much or anything, but I just would like some clarification for my knowledge how this request would affect future wells and how if the pending forced pooling rule that is likely to go into effect, how that would affect this request.
Well, obviously, we all are aware the statute's been in place for a couple of years now, and the statute applies in the absence of rulemaking. Given that, we've come to terms with the fact that this is a process that the rulemaking process has begun. So the short answer would be we would expect these pooling orders to apply to any future wells in these units, with the caveat being that we would comply, obviously, with whatever rules were promulgated in the interim.
Okay, yeah, that's how I understand it. So thank you for that clarification.
Okay.
I believe that's all the questions I have. Dane, Mr. Doucette, do you have any additional questions you'd like to ask Mr. Annenson?
No, I do not.
Okay, I think that concludes the division's cross-examination at this time.
Thank you, Gordon. Mitch, I just got one point of clarification. I'd like to look at Exhibit F2.
Okay.
If you can find that.
I can, if you can give me a minute to look through my notes here.
Can you share which page it is when you get there, Mitch?
Say that again.
When you get there, will you tell me which page so I can look along?
Yep. This is for you, Mr. Annenson. This is page 7. And this, Mr. Rogers, can you see this?
Yeah, that's fine. This is the one I'm after.
Okay.
Just want to clarify some things here. So we have mineral ownership, 50% to the parish trust and 50% to Wells Fargo Bank. And then down below, you also have leased and or consenting parties. We have the trust, you have unlocatable and or non-consenting party as Wells Fargo, 50%. What exactly is that?
Well, as the one who prepared it, it's kind of a simple way of saying there's two owners who own. The two owners, one of them is leased and one of them is unleased. We typically identify them as unleased mineral interest owners, but because the hearings deal with unlocatable or non-consenting, we started to identify them so that they are easier to understand as part of the hearing. But it's essentially one of the parties is leased and one is not leased.
Okay, so my question would be, Wells Fargo Bank, a large entity, they seem like they would be able to be located and communicated with.
We can locate Wells Fargo Bank generally. Not surprisingly, Wells Fargo Bank generally doesn't respond to, we need a decision on what you're going to do with 0.2 mineral acres in the Uintah Basin. The reality is they have not responded to the offers or the notice that's been given.
So they're basically they're locatable, but they just choose not to bother with such a small amount.
Yeah, and the reality is with some of these institutional, in my experience, if I can speak to that, is these institutional owners are oftentimes the easiest to quote unquote locate, but the hardest to get to make a decision as to participation. And the reality is sometimes you can locate. I could get online and probably find 500 addresses for Wells Fargo Bank, finding the one who has the one person who knows where to send this to can prove to be, almost impossible at some point.
All right. That's just a question I had as we went through there. I wanted to clarify that.
Okay.
That's all I have. So your next witness?
Perfect. Mr. Sigler, are you still on with us?
I am.
Okay. Thank you for your patience. Will you please state your name and business address for the record?
Yes, sir. My name is Josh Sigler. My business address is 3217 Montrose Boulevard, Suite 200 in Houston, Texas, zip code 77006.
Okay, now I'm pretty sure I saw a picture of you in your slippers at your home office. Are you sure that's your business address for now?
Yeah, yes, it is. Well, the mailing address for sure.
Okay, fair enough. The board and the division, the hearing examiner and division have reviewed your resume, submitted a part of this cause, and have accepted you as an expert in geology. With that in mind, I would like to turn to just a couple of exhibits for you. The plat maps. Again, with everyone's indulgence, I'm going to show one of those and discuss it. That is not what I did. I did this. Okay, so I'm going to leave this zoomed out for a minute. Do you recognize this exhibit E?
Yes, sir.
Okay, and there are serial exhibits after this. Exhibit F, Exhibit G, Exhibit H, Exhibit I, and Exhibit J. Those are also, in fact, I'll pull one up so that we can get confirmation from you. Exhibit F. Do you recognize these exhibits?
Yes, sir. I have reviewed all of them and recognized them.
Okay, these are business records of XCL.
That is correct.
Okay.
As you stated with Mr. Annenson, plat maps for individual wells.
Perfect. So Exhibit E, if I can go back to that. Exhibit E is the one that we'll discuss in detail. This applies to the 14 and 23 drilling unit. Is that correct?
That is correct.
Okay. Please kind of walk us through this. Tell us what it shows, what the point of it is, and just give a quick orientation.
Yeah. It's overall an overview map of the two sections that will be drilled as part of the Butcher Butte 2374H21 well. We have a solid filled circle to represent the surface location. And then the planned path of the wellbore is then designated in a dashed line that shows both the landing point and the effectively the kickoff point for the lateral section.
Okay, so if anyone can see, there's a dark circle here that shows the surface location. It looks like the wellbore goes back toward the southern border of section 23.
Correct.
And then that's where the lateral kickoff begins, and the productive interval begins to go north through section 23 and into section 14, where it terminates at this circle at the end that's identified as target bottom hole.
Correct.
And that would be the same information that would be depicted on exhibits F, G, H, I, and J for the 30 and 31 wells?
Absolutely.
Okay. Now I'm going to, oh gosh. It does not. There we go. I'm going to turn you to, excuse me, to exhibits M through R. Excuse me, Mr. Annenson authenticated these earlier, so I won't bother asking you that, but excuse me. Exhibit M.
Yes, sir.
Exhibit N, O, P, Q, and R. We'll discuss again Exhibit M. Can you tell the hearing examiner what this is and what it shows?
Yes, that is the authorization for expenditure document, originally prepared by Axia Energy as our predecessor, but as you authenticated with Mr. Annenson, it is an official business document for XCL Resources as well, and it details the costs for drilling and completion of these wells here in the Uintah Basin.
Okay, and because these numbers are so small and the screens are difficult, just to make sure that people watching the hearing online can have this information readily available, can you please identify the estimated AFE estimated costs for each of the individual wells? For the 14 and 23 well, the 23-74H-21 well?
For that well, it would be $10,713,465.
Okay, and for the
I should mention Mitch, total cost there.
okay, perfect. And please explain that clarification if you would.
Just for anyone who's looking and noticing that there are some series of smaller numbers at the bottom, we do indicate a dry hole or drilling cost, and then the completion costs, sum those together, and that is the total cost.
Okay, thank you for that. For the Butcher Butte 30-21H-21 well, what were the AFE estimated costs?
$10,647,505.
Okay, and for the Butcher Butte 30-61H-21 well?
$10,672,200.
The Butcher Butte 31-114H-21?
$10,109,160.
And the Butcher Butte 31-144H-21 well?
$10,107,685.
Okay, and last but not least, the Butcher Butte 31-64H-21 well?
$10,088,545.
Okay. And so what were the unlocatable working interest owners' proportionate share of costs in the, let me jump up here again to the 14 and 23 DU. What were the proportionate share of the unlocatable working interest owners' share of the costs in the 14 and 23 well?
Yeah, at the time of preparation, those costs were roughly 8.7%, which come to $932,487.78.
Okay, so the unlocatable working interest owners in the 14 and 23 DU owe approximately 10%, roughly, almost $1 million in well costs for that well.
Yes, sir.
Okay, and the 30 and 31 DU, can you just do a collective cost, what those unlocatable working interest owners owe for their proportionate share of all 5 of those wells?
Yes, sir. The total there is $188,909.64, and that's roughly 0.366% of the total.
Okay, so together, XCL has paid approximately $1.2 million, rough math, on behalf of the unlocatable working interest owners in these 2 drilling units?
That's correct.
Okay. You don't include, I notice, plugging and abandoning costs in the AFE. Is that standard practice for XCL?
We do not include those, assuming that's a later expenditure down the line, separate from the drilling and completion of these wells. But that is roughly $100,000 or more for each well.
Okay, so if you had to put a number on it today, and I hate to put you on the spot, but what would your best estimate be of plugging and abandoning costs for each of these 6 wells?
Absolutely. Obviously, your standard statement about foreseeing future costs, but currently it'd be roughly $100,000.
Okay. In your expert opinion, are these costs, both in the authority for the authorizations for expenditures in exhibits M through R, and the plugging and abandoning costs that you estimate, are those reasonable, fair, and necessarily incurred in drilling these wells?
Absolutely. In fact, the AFE costs are actually derived from the costs of the actual wells that have been drilled and completed. So those represent the best guess that we have from the history of wells that have been drilled on this property.
Okay.
And similarly, plug and abandon costs are an estimate from past liabilities.
Okay. And briefly, if you could, could you talk about the risks involved in drilling and or completing these 6 wells?
Absolutely. One of the things that's really great about drilling in the Uintah Basin is that there's limited risk of a dry hole, but these wells are so prolific and have so much subsurface pressure. Each of these wells has a pressure gradient in excess of 0.8 psi per foot. And that means we have to utilize specialized equipment such as managed pressure drilling to make sure that we're drilling these wells safely and effectively. But as we do so, we still encounter a great risk that these wells may encounter issues through the drilling and completion process. And so that we're incurring a risk each time we drill that perhaps we will not get the planned production back from these wells due to that overpressured nature, just the inherent risk of drilling oil and gas wells.
Okay, so if I can sum that in my language, there's less drilling risk, but there's lots of kind of operational drilling risk.
Absolutely.
Okay, and this actually is the other reason that you have appeared before this board in February of this year in cause number 47501 is an example of that kind of inherent operational risk, is it not?
That is absolutely true. From time to time, it occurs that some of these wells are trickier to drill than others, and these AFE costs are estimates, and sometimes those tricky wells may cost more, or may still end up with a lower productivity due to some of the operational complexities.
Okay. In your expert opinion, Mr. Sigler, does the risk inherent in drilling these wells justify the 100%, 300% risk compensation award that XCL is requesting today?
Absolutely. I believe these wells, while very prolific, they're still very capital intensive, and XCL can't just go carrying people's interest to the tune of $1 million or more on every unit, and then just let people back in when they know that the wells are safe to enter.
Okay. I appreciate that. With that, I am done examining Mr. Sigler.
Okay, we'll turn some questioning over to the division.
I don't have any questions at this time. I think I defer to Mr. Doucette to see if he has any questions regarding this witness.
No, I have no questions.
Okay, so no questions from the division at this time.
Well, thank you, gentlemen, very much.
Thank you.
Thank you.
Okay, Mitch, do you have anything else to add, or should we turn the time over to division for?
Let's turn the time over to division. I will. I'm done presenting our case in chief. Oh, I don't know if it's an appropriate time now to move for admission of the exhibits.
Oh yeah, we could do that now. Get that taken care of.
Okay, I'd like to move for the admission of petitioners exhibits A through AT. In addition, it's often requested, although not my standard practice, to admit the exhibits that were included with the RAA. If the division would like those to be included, I'll move to admit those as well.
Okay, we can do that too. Okay, Julianne, did you get that? Maybe she's not online. Okay, so it's A through AT, and then the original exhibits from the request for agency action.
That's correct, and I will, pursuant to your request, Mr. Rogers, I will update the and Mr. Rowe the exhibits that have changed based on HC Rigidide's participation.
That won't be that big a trouble, will it? Because you're gonna have to do that anyway for the order, correct? If that comes about.
I'm happy to do it. Trouble or not, we're happy to do it.
Okay.
Yeah,
Okay.
no-
we'll turn-
No objection from the division on admitting those exhibits.
Okay, Mr. Rowe, does the division have any thing to present or any recommendations?
So the division, well, first, I'd like to take some time to thank everyone for dealing with us all in this process, particularly the IT staff and Julianne Carter. I know that it's these hearing examiner processes are difficult for the board secretary, but really everyone here, I appreciate it. I think this went smoothly, and I think we're getting the work that needs to be done done. But as far as this matter, the division does not have a formal case in chief. The division supports the request, and we're grateful for the clarification. Our main concern was concerning the risk compensation award, and with the clarification that that's coming in at 300%, I believe the division supports this request. And that's really all I have, unless Mr. Doucette has anything to add.
I guess not.
The only thing I have to add is just maybe in the future on, I think it was Exhibit E, where we listed the unlocatable and/or non-consenting owners. It would be helpful if there was a distinguishment between unlocatable and non-consenting.
Okay. Okay, we appreciate your
I will take that fully. One note, Mr. Doucette, is it sometimes is difficult in the sense that it should be certain whether someone is unlocatable or simply refuses to consent. The reality is when you mail it to an address, sometimes they get it. You don't know if they actually have gotten it. Someone at that address has signed for it. And so we will try our best to distinguish between the two, as long as there's some understanding that sometimes it's difficult to understand or to kind of interpret their silence.
Fair point.
Okay.
Okay, I'm going to go offline for a little bit here and confer with my counsel. So if you'd be patient with us and hold on, I'm going to disappear for a minute, okay?
Okay.
Okay, I'm back. The division has supported this, and my findings are that I believe that I will recommend to the board that we recommend this force pulling action as requested. Mr. Mayo, could you prepare that order?
Yeah, I'm happy to do that. And we'll try and do it. I know the hearing is next Wednesday. We'll try and do that and get a draft order out by Monday so that division has a chance to review it and approve it before the Wednesday hearing. Is that sufficient?
Yeah, I think that should be.
Okay, we'll get it out as quickly as we can. If we can get it out Friday, we will. If it's Monday, we'll get it out.
And then there's some points of clarification. I mean, these were mentioned during the hearing, but just let's reiterate that 300% is clear. That was something I'm wanting to be in there. And I noticed there's a lot of letters from Axia, but now we're XCL. Just, define in there the transaction and how those are business documents that were transferred. And so anything coming from Axia is now representing XCL. And then update those exhibits with the new percentage of ownership and participation.
Okay, so let me make sure I'm clear. So I've got all the things I need to do here. The hearing examiner is recommending approval, and I'm to prepare the draft order. Clarify in there that we are requesting a 300%, 100%, 300%, and not the statutory maximum of 400. That Axia business records through the transaction have now become XCL business records. And the last one I did not write down. I apologize.
Just, with the new participation or those leasing to you, just so those documents are updated so we know the current participation of those entities. I believe there was only one that added in. Is that correct?
HC Rich Sagmich.
That's right. Okay, we will do that as well.
Okay. Other than that, I think we're going to conclude this. I want to thank everyone involved. I thought it went very smoothly. And so appreciate to the tech staff and to Julianne Carter putting this together in the division. If there are anything else that someone would like to bring up, if not, we'll conclude this.
Thank you very much, Mr. Rogers, everyone. Much appreciated on our end as well.
Okay. Thank you to you.
Thanks, Mitch.
Thank you so much, guys.
Thank you, guys.
Thanks, Joe.
Thank you.
Bye.